undercut. So the regularity is another one for us. So I think we just need to make sure everything's tight and the legislation's written in a way that we don't have loopholes which is going to see people being exploited.
The government's obviously given itself an awful lot of order-making power and is proposing to push many quite significant questions into consultations. Are there particular issues that you would prefer to be on the face of the bill written into primary legislation? And if so, why?
The key one for us would be the 12-week reference period. I know there's a pushback from employers around this, but the 12 weeks is already recognised within the industry in terms of its redundancy. It was within holiday pay. The Conservatives changed that to a year, but it works. And that 12-week reference period gives the time to iron out any sort of bumps along the way. Yeah. So we're absolutely clear that 12-week reference period should be on the face of the bill.
Okay. And then are there any other loopholes that you think might be quite risky to leave to a consultation or indeed to secondary legislation?
I think when you have anything in secondary legislation, it's open to an incoming government who may not be as empathetic or sympathetic to change. And that's why I think it's really important that this tighten down as quickly as tight as we can to ensure that any future governments don't undermine it again. But for us, it's low hours contracts and low hours in the bill we think should be excluded from it. And the 12-week reference period should be on the face of the bill. That's absolutely clear from our perspective.
Perfect, thank you. Sonia Kumar.
How easy do you think the bill's proposed reforms to zero-hour contract and low-hour contracts are to be implemented to by businesses? Do you think it will be difficult? Do you think it'd be quite an easy implementation process for businesses?
Well, personally, I think it'll be quite smooth. We'll have one of the biggest retailers. You can mention the companies here. I mean, we have Tesco's, which is got minimum 16-hour contracts working alongside us, and that works really, really well. I think you can overcomplicate it, and overcomplicating it then leaves loopholes. And you need to keep it as simplistic as possible, ensuring that the legislation is tight.
Do you think sort of SMEs may struggle in particular with the implementation of this bill?
Well, you've got to look. Firstly, our primarily interest is to ensure that people are fairly treated at work, fairly rewarded at work, that people can go to work and they know what their earnings are going to be, they know what their hours are going to be. They're not going to have them changed at an employer's whim. Which puts them out. And if you take people that's on low hours contracts and continually, our biggest one is having low hour contracts. If you're on a contract, say 10, 12 or 15 hours, and continually week on week being asked to work 20, 25 and 30 hours and not being able to work for another employer, that's unfair. And of course, if you make a complaint and you're not the trade union organised site, you have them hours removed and you've no recourse. There's no legislative recourse to it. So this is about making sure there's fairness, that people know when they go to work they've got an income, they know what hours they are. And that's why the contract of the reference period is so important to have that in. And it works also for agency staff as well. The agency, I know you'll probably hear evidence today, the 12-week reference period will work for agency, and after the first 12 weeks, then the onus should then go on to the hirer, whoever the hirer is.
Same question to you, Neil Cumbry. How do you feel like businesses can implement sort of these zero-hour contracts and low-hour contracts?
So I think that it is important. The balance of what's on the face of the bill and what is dealt with in regulation is a challenging one. I mean, by definition, I think trade unions, businesses like to see things on the face of the bill, but there's a lot of detail to work through here. And the bill arrived very, very quickly. There are some aspects of it where there is just going to need to be some time where businesses, government, trade unions work through details. I think for me, the primary challenge with zero hours contracts is the provision to apply them to agency workers. I think we're dealing with a very different world when we're talking about agency workers than direct employees. A lot of and Paddy's just articulated, a lot of the concerns about zero hours contracts used by direct employers are you're effectively in a monopsony. The employer has the ability to switch up, switch down. Zeros contracts as used by agencies, agency workers will typically be signed up to multiple agencies. Within those agencies, there are multiple clients where a worker could be placed. One of the things that we know that agency workers feed back to us is that the value of being able to say, I don't like it there, I don't want to go there, can you put me somewhere else, is actually quite important. So when we think about the power extending to agency workers, for me, 1 million people went to work as agency temps this morning. The articulation I've heard from government of why agency temps might be covered by these powers is we want to avoid bad direct employers using agency as a loophole. I'm not sure those 1 million temps should be taken for granted like that. I think we need to think about the fact that agency workers are protected by their own act, 2 sets of regulations, an independent regulator, which, by the way, needs more resource, and by defined statements of terms or in key information documents. I think we need to deal with agency differently. 2 suggestions for us. We might suggest looking at strengthening some elements of the agency workers regulations, and we might suggest doing more on hours in the key information document agencies get. But it feels to us like there's a real risk here of, in an attempt to avoid some evasion by direct employers, bringing 1 million temps in to this regime and driving some of the behaviour we've seen reported in the last month, where some direct employers are using platform sites that engage people who are patently workers as self-employed. I think the real enemy here is false self-employment. That would be our primary concern about the practicality of the bill.
Thank you.
But I just want to understand your view on whether the minimum period should be written into the face of the bill or not. Where do you? I know it's you point to the complications, but where do you come down on this question? If I put you on the spot,
we favour a longer reference period to allow for seasonal demand.
Yeah.
To be completely honest, on this one, we start from the business. We want the law to be right when it hits the business, whether it's in primary or secondary, is not what our members are talking to us about.
Interesting. So actually, you could be reasonably comfortable with it being on the face of the bill, but you'd like to see.
Yes.
Let's do that. Okay, Antonia Pence.
Thank you very much. And it's interesting that we spoke, Neil, Mr. Carberry, about the use of agency workers as a loophole, and we will come on to the business model of Sports Direct in a moment on that point. Yeah. But I've written down here a note that the average length of assignment for agency workers in 2023, according to your own statistics, was 22 weeks. Now, that is not what most people think of when they think of a short or a temporary assignment, and that will be well over the types of reference periods that we're talking about. Given that is the nature of agency employment on average in the industry you represent, I don't understand why you are so resistant to the extension of a minimal set of new additional rights for these workers who are working on long-term assignments.
So the government has a goal of 80% employment. I have to tell you, right now, it's not going that well in the labour market. If you look at statistics, I'm in the Daily Mirror this morning saying the country needs a dose more optimism about these things. So I am an optimist about what we can achieve. I am genuinely worried that all we end up doing if we extend these powers to agency workers, because, and this is the logic the government has set out, because it avoids evasion by direct employers, not because there's any failure in agency regulation, although we might agree that proper enforcement of the current law is necessary. I think you just end up driving more self-employment, more false self-employment. And that's my primary driver for being concerned about the inclusion of agency workers. The bill has nothing. You asked Paddy earlier about exclusions in the bill. This bill has nothing to say about the primary thing that my members think the government should regulate, which is the use of umbrella companies.
Interesting.
And that is a major lacuna. Again, apply it to agency workers, but not to umbrellas. I think actually, if you look at the definition of the employer in the bill, it probably reads as maybe including umbrella companies, but we'll find out, as we always find out, which is in 7 years' time or 8 years' time, when Paddy or one of his colleagues supports a worker to bring a claim and the claim gets to the Supreme Court. It's not really kind of where we want to be. So we are genuinely concerned that actually it may feel like extending these to agency workers is an easy step, and actually in those long assignments, as long as the relationship remains with the agency, it doesn't transfer to the hiring company, probably we could make it work. It's the impact on the service buyer that we're worried about, and some of that levelling down that we've started to see evidence of. We're
going to come back to agencies in a second, but again, just on the reference period, if you say actually you could live with it being on the face of the bill, and it didn't sound to me like you were wholeheartedly embracing 12 weeks, what would be the number? I mean, if you, just given everything that you know, everything that you've heard, if you had to take a number now, what would it be? Ballpark. Give us a range if you want.
Most business organisations defaulted to 52 weeks. I think you need. Let me finish the clause. I think what you need to do is account for seasonality. So I would be more in the territory of 26.
Yeah. Okay. I just want to make sure we've got the range. Alison Gross.
I just wanted to go back to the earlier question to Mr. Lillis on SMEs, because you gave an example of Tesco, who you had worked with, who are obviously one of the largest, most successful businesses in the UK. The question about SMEs, I don't feel you answered. So could you please, in the shorter sentences, perhaps give us how easy it is going to be for SMEs to implement this and what the consequences will be for them?
Well, it shouldn't be consequences. I mean, we're asking that when people go to work, they know what their hours are and they know what the remuneration is going to be for it, whether you're a small employer or a large employer. We don't see there being much of a complication there. As I said, keeping it simple is what's more important to us. And if you look, I mean, if you don't mind, in terms of, I mean, there's been a number of things that have been done. The last government had the Taylor review, Matthew Taylor review, about one-sided flexibility, and they said it's one of the biggest causes of concern in industry, at one-sided flexibility. It was never implemented by the government. The Low Pay Commission themselves in 2018 recommended the workers be given a right to a reasonable notice of working hours, compensation for shifts cancelled without reasonable notice, and that workers should be given the right to switch to a contract reflecting actual hours worked. That's the Low Pay Commission making a recommendation to government. And of course the BRC, a report on how to build, retain and empower your retail workforce. They stated creating a mutually understood definition of flexibility. WED would be suggested in favour of employees is key if improvement of retention, engagement and productivity are desired. And we believe, the BRC, that hours which are regularly worked in addition to contractual hours should become the individual's contract. Now, these are all big businesses.
So if you're so confident, why haven't you worked with any SMEs to develop this? Why only work with Tesco?
No, not just Tesco. So I use Tesco's as a reference.
But SMEs, give me some examples of SMEs.
I work across.
To develop this.
I work across mainly the main retailers: Tesco's, Morrison's, Sainsbury's, the Co-op, Home Bargains. You name most of the retailers. We'll work with them. And we've got a union recognition agreement, so when you have a union recognition agreement, you can get to a position where you can have these issues resolved very, very easily working with them. Most of the SMEs are not recognised by trade unions, which makes it much more difficult. That's a different aspect of the bill in terms of access and trade union recognition. I presume it's not going to be raised today, but that's another one that we have made sure the consultation, we've replied to that consultation on it. But I've got a record as a General Secretary of working with employers. I have a close relationship with the BRC, I have a close relationship with the Association of Convenience Stores and James Lohman, the Chief Executive, and the Retail Trust. And we work in a collaborative way with them. We want to see growth in the economy, we want to see retailers do well, but we also want to make sure that employees it's not one-sided flexibility, that there's when they go to work, they know what they're going to get. If you're a retail worker in low hours contracts and not knowing from one week to the next what your hours are going to be, you go to the bank, you can't get a mortgage, you can't rent, you can't get a loan. The insecurity and then what it causes the mental health issues with it as well. We should be a modern economy. We should be looking to improve. And retail has always been synonymous with low pay. And low skilled training. It's not true. The vast majority of retailers want to see their businesses flourish. We've just done a deal with Sainsbury's this week where they went to £12.60 an hour from £12. You know, these are even with the budget restrictions they have on them, and I think there's about £120 million extra with the budget restrictions, and they've still been able to make a big. Now they're a big company. The smaller ones obviously have their own challenges, but it doesn't take away. People should have the right to know what their hours are and know from week to week what it is they're going to be working. That's why the 12 weeks is really important. And agency workers shouldn't be excluded from it. Agency workers should have the same protection. Otherwise, you leave loopholes in the legislation.
Let's get into this question in a bit more detail. John Cooper.
Thank you, Chairman. One of the areas where there's clear divergence, I think, in the bill is the provision to exempt the duty to offer guaranteed hours in certain specified circumstances. And I think that you, Mr Carberry, and you, Mr Lillis, might be on opposite sides of that argument. So can I ask you first, Mr Carberry, and then I'll come to you, Mr Lillis, who, if anyone, should be exempt from that duty, and why do you think that exemption is important?
So our view, as I've already set out, is that agency workers operate in a very different regulatory regime, that they are protected by, as I said earlier, their own act, 2 sets of regulations, their own inspectorate, rules around key information documents, and that the extension of the regime to offer guaranteed hours both confuses the relationship between the agency and their client and creates extends it basically because it's deemed, we're dealing with 1 million people who are deemed to be an invasion route for direct employers. That feels to me a weak basis to include agency work in this. I've said already that there are alternatives that we could use, but I think also, Paddy talked a minute ago about some of the risks, and let me be clear, there are clearly examples of bad practice in every form of work, including agency work. But when you look at, for instance, a Fabian Society, not well known for their radical right-wing opinions, sample of, well, that might be a bit editorial, sample of 2,000 zero-hours contract gig self-employed workers. I might start with the fact that agency workers in there, I'd probably treat them differently to those other groups. 72% of workers are satisfied with their independence at work. A survey of 500 temps that we ran last year, 80% say that their work delivers an important need for flexibility.
Mr Carberry, we could quote similar statistics for McDonald's. The kind of scale of abuse we've uncovered at McDonald's has been fairly horrifying.
Well, I mean, this comes to, I think, one of the critical points, which is, let's be blunt about it, government passes law, it doesn't enforce. And actually the bit of this bill I like most is the stuff about the Fair Work Agency. I think there's a real challenge here, which is the most common feedback from businesses to government at the moment is, if I comply and I take the cost of compliance and they don't, what happens to them? So I think that piece about enforcement really matters. The point I'm making, come back to my 1 million people went to work as agency workers, is within a square mile of this building, we have allowed people who work in ways that are not 9 to 5, Monday to Friday, open-ended, an assumption to build that these people want to work, that's what these people want. I'm going to tell you that is not what a lot of these people want. Two-sided flexibility matters. One-sided flexibility needs to be tackled. Agency work is largely two-sided flexibility, and that's why we want it withdrawn. Agency workers have choice.
Okay. Mr Lillis, what's your perspective on this question? Do you think that there should be exemptions for particular groups of workers?
No, I don't. I don't think workers should be treated any differently, and there shouldn't be exemptions to it. I mean, you've agency, I mean, trying to take agency workers out of it. Agency workers, by definition, are there for peaks and troughs in the business. We know a lot of companies are there for an extent of a year, probably more. And you can't tell me if a business is going to run itself. If peaks and troughs, I understand. I work in an industry, in the meat industry myself, which has peaks and troughs in the business. You need to bring extra resource in, but that's a short-term thing. They should have the same safeguards as anyone else. But in terms of agency workers themselves, you know, why should they be treated any differently than anybody else? They shouldn't be. You know, they're entitled. If you're going into a business, and somebody mentioned a fast food chain, national fast food chain, well, they know the hours they open and the hours they close. They know the peaks and troughs of their business, so they should know how to plan their hours in. And it's about putting the onus back onto, not the onus on the employee, but the onus back onto the manager to manage the business more effectively. And agencies, there's a place for them, but it should be, in terms of peaks and troughs, not being used as a way of sort of either cheaper labour or stopping the hirer from having the employment costs.
Mr. Cooper, anything further there?
No, that's fine. Thank you very much. Yeah.
Antonio Pence.
Thank you very much, Chair. I wanted to ask both Mr. Carberry and Mr. Lewis about the definition of low hours. I think one of the points in the bill that is being left from the primary legislation on the face of the bill is around the group of workers and the number of hours they need to work to qualify for the new protections against 0 hours contracts. What do you think the definition of low hours should be? How many hours is low hours? And how do we ensure that people who work whatever hours they work are not, there isn't a loophole through which their employers can drive? Paddy?
Well, look, again, fairly clear below hours. Anything below full time. Anything below full time is, is part-time hours. Now, in different employers, I'm an employer. Our staff work 34 hours a week, so 34, anything that's full time. Use Tesco as a reference, 36 and a half hours is there. Some industries are 38, some is 40. So there's, in each industry there'll be the standard for what a full-time contract is. But we've already seen an amendment to the bill put in, making low hours 2 hours. But that's a nonsense, isn't it? It's a real nonsense to have that. It should be, if anything below full time is part time, and the reference period over the 12 weeks would iron anything out. So I mean, it's not that complicated.
Thank you.
It's difficult to stick a finger in there, but I think 2 would be obviously significantly on the low side. We've talked about 10 or 16 in the past. The thing that occupies our mind at the REC, come back to my point about umbrella companies earlier, tend to use annualised hours contracts. If you run the numbers on those, it works out to about 7 per week. I think you probably want those contracts inside the scope of any protection. So any kind of annualised hour contract loophole is effectively avoided. So that speaks to a slightly higher number than the sort of 2s or 3s or 6s that we've heard.
Thank you.
Just on this point, Joshua Reynolds.
Thank you, Chair. Mr. Lewis, you said anything below full-time hours is part-time, which I don't think anyone could disagree with, but you didn't really answer what is low hours. Are you really sat saying that somebody that works 4 days a week is on a low hours contract?
Well, the retail sector, which we're talking about, the vast majority of employees are female. The vast majority are on part-time contracts, on average in 12 to 15-hour contracts across the piece. You'll not see only in management grades and senior grades, you'll see full-time staff. So I'm not going to put a number on what part-time. Part-time to me is anything less than full-time.
No, we're not talking about part-time versus full-time. We're talking specifically about low hours. And that's the specifics that are mentioned. Part-time isn't what we're talking about. When I was a manager in retail, we had significant numbers of our team on part-time hours. Yeah. But we reserved what we would have called low hours on a 16-hour-a-week contract or less.
Well, you can have people, yeah.
Really want it. So what would you specifically define as low hours? Not part-time, but low hours contract.
Anything below 10 hours would be low hours contracts.
10 hours. So that's where you would draw the boundary, you think, as an organisation?
Well, it'll be low hours. That to me is low hours. But there'll be people in retail, for instance, who work Sunday only because it suits their family needs. I'm not talking about taking away people's right to want to work less hours. We're talking about putting in, safeguards for those who are working and having to work extra hours and having that levelled out over that 12-week reference period.
Just on this point about hours, Paddy, perhaps you can help me understand exactly, what we're talking about here with low hours. It's the boundary at which protections against 0 hours contracts kick in, right? So do you think there will be an impact if the low hours were, say, set at 7? Do you think there will be then an increase in the number of people on 8-hour contracts? Because at 8 hours, you're not protected against the 0 hours contracts behaviour, the withdrawal of the hours. Do you think that might happen?
Absolutely, and we already have evidence that over the years where, I mean, you have the 16-hour contract that kept people, most retailers were kept 15 hours at a time. So, you know, people will work and adjust, and that's why I'm absolutely clear about loopholes, unintentional consequences. And that's why we also welcome the longer consultation in some of these areas to get this so right. I want to make sure that it's done in a fair way, not only for the employees we represent, but also for the businesses, to make sure they're not undercut or exploited with other employers. So, you know, that's where I would be. Yes, I would say if there's shorter hours contracts, where it be 7, 8, some employers will work around that.
So that was why you said in your opening remarks that you would take the word low out of the face of the bill, just to make it clear that it was all part-time hours, everyone under full-time enjoyed protection against the behaviour that we've seen through 0 hours contracts.
Absolutely correct.
Okay, thank you. That's really helpful to understand.
Matt Weston.
So do you think there'd be any merit? I'm just sort of, this is kind of nebulous thing that we're trying to understand, and numbers are almost very an abstract thing, but do you think there's any merit in the government looking at linking hours, particularly on national minimum wage, versus cost of living as a metric? So low hours becomes a relevant number when you actually pin it against people's ability to actually pay their bills. Do you see where I'm going with that?
Is that a question to me? Sorry.
Yeah, sorry, Mr.
Oh, sorry. I thought you would pass it to someone else. Sorry, repeat that again. Sorry.
I was just wondering if you thought there might be something of merit in the government looking at, rather than the abstract of like whether it be 10 or 7 or whatever. I mean, it's kind of an odd way to approach it, but that there is a link between the number of hours at national minimum wage and, say, cost of living. What we used to call the breadline back in the day.
Well, that's a difficult one. It's different for different individuals. We have people at the minute are working 3 jobs, you know, because they can't get the hours in one employer, they're having to go to other employers. There's some employers where they are working and they're curtailed to that employer, they're not allowed to work elsewhere. So there's all sorts of restrictions in there. And it comes back as far as we're concerned, it's not difficult. In retail, there'll always be part-time contracts. It's the low hours contracts where people are taken on a 10 or 12 hour contract and consistently worked 15, 20, 25, 30 hours a week. And if you make a complaint around that, them hours are taken off you, and there's no redress for that there. This is about fairness. It's about fairness in the market. And most employers, by the way, the vast majority of employers comply and work in a collaborative way. This is to ensure that the ones who are not, that it's dealt with. And colleagues said there about the fair employment agency or whatever. I mean, we've got issues in terms of enforcement. And that's going to be a challenge for government as well, because even the employment tribunals, I mean, are 2 years behind them. And there's going to have to be major resources put into that to try to help and support as well. So I'm not saying all this is simple. I understand the complexities of it, and it's going to take time to work through. But it's about fairness, it's about justice, it's about making sure we've growth in the economy and making sure people's treated properly.
Okay. We just want to close off on agencies before we move on to some questions about the reference period. Mr. Carberry, I mean, have you said what you need to say, do you think, on the risks in your eyes of this legislation biting on agency workers?
So there's probably one other thing that I'd add as a potential loophole. I mean, we've talked about, I entirely take Paddy's point about treating different, but we do treat agency workers differently. That's why they have a different legal regime. The bit that is perhaps a bit kind of niche and only interesting to me is transfer fees. It's transfer fees and the proposal to potentially abolish transfer fees, where an agency temp becomes the direct employee of a hirer. I'm going to caution the committee on that being a potential loophole to just forcing direct hiring into doing it via my members. Now, my members might make some money out of that, but I don't think it's good for the labour market. We are really clear that there was a lot of effort went into how transfer fees are controlled by the 2003 conduct regs. We are really strongly of the view that you keep transfer fees no matter what to avoid unscrupulous employers wanting to just hire a load of temps and then move them across without recruitment costs, and you end up in a situation where people who would have been hired directly spend 6 months as temps with a different status, and think that's probably not the labour market we're trying to build.
And you lamented the omission of anything on umbrella companies in the bill. I mean, if you were writing the bill, what would you have liked to have seen on umbrella companies in the bill?
I mean, umbrella companies are largely acting as the employer for a percentage of temps. They are, once they exist in the sector, they're quite difficult for agencies who payroll their own temps to compete with. There are good standards around the FCSA and others that audit umbrella companies, but there are also examples of pretty poor payroll practice in the sector. We would like to see the kind of regulation the Employment Agencies Act, the conduct regs, brings to agencies, to employment businesses, brought to umbrella companies as well.
Okay, thank you. Let's move on to reference periods. Antonia Vance, let's kick off on that.
No.
Well, let me put the question then, perhaps to Mr. Lillis. So we're having a debate about how long somebody should be employed before they can request a permanent contract. Do you have particular views on that question?
Well, we've said the reference period should be 12 weeks. So the first 12 weeks will be at reference period. So it'll be when you go into the 13th week, that's when you start to look back in terms of what hours is worked. That's what it comes back to what I said earlier about managing your business, managing your shop, your retail store. You manage it properly. You'll know the hours you need in the business. Of course, there'll be peaks and troughs you have to work through. But in the main, this gives stability to employees. They're going to know what they earn and the hours they're going to be working. And that's really important to have that security of employment and security of knowing you can pay your bills.
Perfect. And Mr. Carver, you're at the sort of the 22 weekend of... Yeah.
Yes, and although Paddy mentioned the Low Pay Commission report and the lee of the Taylor report, or I should say, for full disclosure, I was one of the employer members of the Low Pay Commission at that time. So I think the concept that the government is trying for here is one that I think I and lots of businesses have sympathy with. It comes right back to something I said earlier, which is we judge it on the practicality when it reaches our businesses in the context of everything else that government is asking businesses to do just now. But yes, broadly a longer reference period.
Can I just check, because Paddy, you said, I think in your opening remarks, that 12-week reference period was used for holiday pay, and it's very recently got rid of. I think last 2 or 3 years it was got rid of for holiday pay. So many employers will have systems that enable them to operate a 12-week reference period for those types of rights. And there are other rights that require a 12-week reference period. So aligning around a 12-week reference period would make sense in terms of the payroll and hours tracking systems that employers would have to have in place, wouldn't it?
Easily understood in the industry. 12 weeks is a reference period. Redundancy, particularly redundancy, but maternity, paternity. Holidays is correct. It was just changed recently by the last government, made into 12 months. Yeah. But it's recognised, and we've never had an issue with it.
Okay, thank you. Just want to nail that down. Right, Joshua Reynolds.
Thank you, Chair. In the bill, it says that workers on 0 hours or low hours contracts need to be given reasonable notice of shifts that they're asked to work, but it doesn't define reasonable notice, and it puts the onus on the Secretary of State, who says that they could specify what that means in future regulation. What is reasonable notice, would you say?
I think this is a really difficult question. I don't say that to throw...
well, that's why you're here, Mr. Colbury.
Well, thank you. To throw rocks in the path, because I think it legitimately will differ from sector to sector. And this is one of those areas where I think secondary actually is quite a good approach. For us, clearly, large businesses with capacity, as Paddy was talking about earlier, to schedule properly are already getting better at making sure people have more predictability. Certainly we're seeing in the contracts that our members are signing with large businesses for instance, shift cancellation payments becoming commercially more common. You know, nobody wants a position where someone's arranged childcare, paid for the bus, got to work, is standing in a queue when they get a text. If someone's there, they should be getting a payment. Our only point would be that payment should be paid by the people who made the decision.
But for all of its complexity, what's the virtue of keeping it in secondary legislation rather than providing some clarity on the face of a bill?
Fundamentally, this bill...
Make up our mind.
Well, I think genuinely it's a bit like when we were talking about 12 weeks a minute ago, there's an employment relations aspect to this, of working through with unions and businesses in sectors what is reasonable. Because by definition, in food production, where demand changes very rapidly in the summer on the basis of the weather forecast, we might be more sympathetic to shorter periods than in a plant where demand is pretty stable.
You said though earlier, you said about sector by sector, and that's the way that you think it should be done. But then equally, you said in an answer earlier about how sometimes you only actually know things when Mr. Lillis and one of his colleagues ends up in court and it gets decided to sue the courts. Yes. So sector by sector, that doesn't mean anything though. If you take grocery as a sector, where you've got large business and small business, could the discounters then say, actually, we're not part of the normal grocery sector, we're part of something different? How far can you get down before you go, actually, you can't just go sector by sector because the sector doesn't mean anything?
Yeah, look, I think go back to where we started, this is really hard. By definition, I don't think what you want to do is to end up in hundreds of subsectors. But there must be an allowance in wherever we end up to say that there are legitimate and rapid changes of demand, that then it is reasonable for employers to offer shifts or remove potential shifts based on the fact that they just will not have the money in the business to pay for those shifts.
Were you saying that there should be different reasonable periods for different sectors of the economy?
I think there should be different reasonable periods based on different circumstances, whether when we get into secondary that proves to be different sectors or circumstances listed in the secondary. I don't have a good answer to that right now, and that's actually one of the reasons why I think we need to spend some time on it in the secondary.
How long would it take to figure this out? I mean, we've been debating this kind of issue for some years now.
I think it just needs a period of focused work by the department, working with unions and businesses.
Is that a week, a month, 5 years? I mean, how long do these things take in your book?
The LPC report we discussed earlier took a year to put together. Now, if we're talking about 2026 application, if we get going as the bill is going through passage here, we could come to a reasonable outcome on this during this year.
Ms. Liz, on very much the same question, in your area, in your specific sector then, what would you say is a reasonable notice period for someone to have a shift cancelled or be given a new shift?
Most of our collective agreements is a minimum of 4 weeks for changes of shift. And of course, if you bring in compensation to it, the closer you get to a cancellation, then the more should be the money should be paid. But yeah, 4 weeks should be the minimum.
Do you think the bill, though, differentiates between set hours on that 4-week notice versus short-term sickness cover or short-term cover? And are we then going to run into a problem where a worker is asked to very quickly come in with 2 or 3 hours notice and then they're asked to be compensated?
Well, I think that's why the consultation is so important. There's a longer consultation around this with ourselves and the employers to get this right. That we recognise there'll be occasions when there'll be sickness absence, which will put a pressure on a smaller business and not necessarily a large store. But we can find ways around it. We do it already with the collective agreements we'll work through it. I go back to this is more for the individuals who are not playing ball, basically, and take advantage of their employees.
In terms of compensation then for shifts, if shifts are moved or cancelled at short notice, what level of compensation is appropriate?
Depending how long it's been, I mean, if they're given short notice, then they should be compensated for them hours. They should be
short notice also, however much the idea of the level of compensation isn't defined, short notice also isn't defined, and moved isn't defined either. So
it's hard.
If you had a scale, where would you say that scale should start and finish in terms of levels of compensation?
If I'm asked to come into work, and I've scheduled myself to come into work for a 4-hour shift, and it's cancelled, I'd expect to be paid for that. I've closed off the rest of the day. I've made myself available. Why should I suffer? Because the employer hasn't managed their business properly.
And at what point?
There'll be exceptions and open time to time, but in the main, it's down to managers managing. It's an easy one not to manage, because you can just hire and fire people. I mean that in a light touch, but they don't bother coming in the day because there's no repercussion. If you're having to pay for it, you'll manage your business a bit better.
Would you start that? Would you say 4 weeks? If you give 4 weeks notice, you would say, would 4 weeks cancellation be appropriate for a compensation payment?
I think so. I mean, at the minute, within our agreements, we have a minimum of 4 weeks for a change of shift, a change of any pattern. Of course, if you want to change it, if it's a temporary measure and you want to change it back, then you've got to give that 4 weeks notice again to change it back. And that's important, so employers are not just using and abusing the system. Because if you're going to give notice to change their hours, then you've got to give notice to change it back, and that makes the manager manage more appropriately.
Matt Weston.
Yeah, I'm just interested to drill into this, because it's an area I'm not at all familiar with, and maybe Mr. Carberry, just to understand to what extent, what sort of notice periods are typical in some of this, when you talk about sector specific. Could you just give some examples of kind of a more extreme sector at each end, what sort of notice they might give?
Most extreme sector, food production in the summer. I mean, you might know better than me, but lead times for ordering some foods are 3 and 4 days. Weather forecast suddenly changes. We don't need all that ice cream anymore because it's going to be a typical British summer. So we pull stumps on the order and we're not producing as much. That's at one end, and at the other end you have kind of things like a traditional heavy manufacturing plant where demand for new cars, a few months ahead you should be able to schedule people to work in that very much the way Paddy sets out. So again, it's that circumstantial situation. The one thing I'd just put on the table as we pass by it is to be aware about, certainly in our sector, but I think increasingly elsewhere, how people choose shifts. And I use an example of this, and forgive me if any of you have heard me use it before, I use it rather too much. But one of our members fills all of the Christmas shifts for one of the major retailers up at Magna Park in Milton Keynes. It's 3,000 jobs, 3,000 seats, every day, 14 weeks from August to Christmas. 10 years ago, you need about 3,500 people to do that. Some people took a week off. Some people unfortunately got sick. That did the job. Now you need about 11,000 candidates to do that, because the march of technology means that many agency temps in particular have apps from their agencies on their phone. They can see the shifts that are available. They go, do that one, I'll take mum to the hospital, then I'll do that one with the other company. So there is a level of choice going on here. So the reason for mentioning this now is not just to emphasise how what some workers want is changing, but also to point out that what it is to offer a shift is a really challenging question, because if I as an agency put a shift onto an app which a worker has access to, have I offered them that shift? Because I've actually also offered it to the other workers who might take it. So there's some work in the consultation to do just to get that right as well.
Let's come back though on the point, the extreme example you gave. I mean, the weather forecasts are pretty good 2 weeks out. So with the example of the ice cream manufacturer, it's not like the 1980s or 70s where the forecasts were much more immediate. Surely they gauge up for the sale of barbecues or ice cream or whatever. They know what's happening. Really good retailers know exactly what's going to be happening in a few weeks' time. So surely the much longer notice period could be given. And then secondly, I was staggered to see that 66% of workers are not getting any compensation for less than 24 hours notice. That's a disgrace, isn't it?
Well, we're on record as, I both was a co-author of the Low Pay Commission report that suggested doing this, and the REC does not oppose this. And I've said to you already that many of our commercial contracts in the sector are now allowing for payments, particularly very short notice payments. I think the challenge here, I think the Met Office will be delighted with your feedback. The challenge here is exactly, let's have the discussion, as Paddy's pointed out, about what the appropriate length is, but that's a discussion to work through rather than just picking a time span out there.
It is a disgrace, though, isn't it? Less than 24 hours, not getting any compensation.
I've said what I've said. I believe if you are arranging childcare and paying for transport to work, and then your shift gets cancelled, you should be paid.
Okay, thank you. Alison Griffiths, did you want to come on?
Yeah, I just wanted to come back to the seasonality point, though, and just to ask Paddy in particular, but Neil too, for those seasonal businesses which are affected by the wonderful British weather, like amusement parks in my constituency, what do you recommend? Because if they do have day after day of bad weather where there are no tourists to be seen, no one walking through the door, what is your prescription on how they should handle that? Because I can tell you they are extremely concerned about having to pay on for days where they won't be receiving income themselves.
Not half as concerned, of course, of the worker who's wanting to turn up to have it.
I'm not the one pushing this. I'm asking you to give your prescription for those businesses, what they should be doing, how they keep their businesses viable, even in the event of not being able to manage their costs when they haven't got income coming in.
We're talking about excluding what industry, so you talk about the agricultural industry, you talk about the food sector industry, the hospitality industry.
I'm just asking you a straightforward question. What do you want me to say to the employers in my constituency who have asked me this specific question?
Well, I don't control the weather. That's the first thing. I mean, they are employers in an industry. They know the risks that comes with that. But it's been for too long. The employees had to take the burden of these things, and the employers haven't taken the burden of it. So they're going to have to deal with it some way. But again, that's why you need a longer consultation period to deal with the issues around the complexities of people who can deal with seasonality. While you're working in the fields in an agriculture work, or you're working in the meat industry where it's seasonal and something goes wrong. But that's, again, I said at the start here, the consultation is really, really important. And most of the areas where we work in, and I say this, is the trade union recognised, we work through issues and concerns, we resolve problems together. Most of the areas we're talking about here are areas where there's no trade union recognition, so it's left to the whim of the employer most times, and the employee is the one that suffers with it.
I need to move on to Mr. Brown, because you've been very patient listening to this debate. So let me turn to Sonia.
Thank you, Chair. So it's coming to the Frasers Group. They committed to end zero-hour contracts in 2016. Why did you break the promise?
I expected this question would be asked. So I wasn't around in the business at that time, not in any way abdicating the position, but I think what I can talk to is the reason that we do continue to use them today. I've been, firmly enrolled since 2020, and it talks to some of the examples of the things that have been discussed so far in this forum. We employ 11,500 people on zero-hours contracts in the business, and we don't see a benefit if those zero-hours contract workers are dissatisfied with the way in which they receive their shifts, that the churn is higher than it should be. So we've implemented a number of safeguards and ways of working that ensure that there is as much certainty around hours as possible. To the debate we were just having.
What are those safeguards?
Absolutely. So we have requirements for shifts to be issued within certain time frames ahead. So we give managers access to hours to be able to issue them 4 weeks in advance, and we ask that they're delivered within 2, and then they're enforced within 1. So absolute worst case scenario for any workers, they would know at least a week out when their shifts would be working. We have a principle of not cancelling shifts where it's outside of exceptional circumstances within a week of them being issued, to try to give that certainty. Our commitment to the people who come and work in those under those contractual conditions with us is to try to give them at least 12 hours, access to 12 hours if that is what they want of work a week. We averaged in the last 12 months 16 hours of work per 0 hours worker.
In what circumstances would you give someone just 1 week's notice?
In a circumstance where there's been sickness by a manager who's responsible for setting the shifts, exceptional circumstances. It's certainly not the norm and certainly not an acceptable practice. We have a suite of central reports that are issued by our central retail operations team that go out to the field managers and area managers of stores to make sure that these rules and standards are being met, because we genuinely believe that the importance of our 0 hours workers is fundamental to our business. We don't operate without them.
And how would you, so with this now low level of guaranteed hours, so would you say this be 16 hours then that you'd be offering to your employees?
So currently that is the average that's been given over the last 12 months. I think it's a really interesting challenge. I think I can only really talk to Frasers Group's examples of what that looks like. As I say, we aim to offer 12 hours for people. That's our sort of minimum standard. I think the reality is it's dependent on individuals. So ultimately, as a business, we're trying to balance the needs for flexibility of the individuals who work, as well as obviously our own needs to balance how we deliver resources against the peaks and troughs that we have. And seasonality is a really interesting point for us. I mean, I think Paddy's point on a 12-week reference period being a standard and something that should absolutely just be simple to employ. But if you take 12 weeks in our business, between November, December and January, that's a very different position as 12 weeks between February, March and April, which are some of the quietest times of the year for our business. So I think there is a real point around reference period that needs to be considered. Clearly different businesses and different industries will have different seasonality. I can only give you that example from our side, but for the principles of putting in protections for people who are on low or 0 hours, we agree with that. We've put our own in. I think a lot of them talk to some of the proposals in the legislation. I think the importance for us is, one, trying to balance that with the flexibility businesses need to deal with things like seasonality and changes in circumstances.
Well, you're talking about seasonality, but you would already know this, you've got the data, so year on year you know when there's going to be busy periods in your industry. Absolutely. And when there's going to be peaks and troughs. Yeah. So that would be built in, and I'm assuming, is this bill something that you would be happy to fully adopt?
The principles of it, certainly. I think anything that gives employees better protections is something that we genuinely do agree with. Our business takes, in the case of 0 hours, that is a group of people that are extremely important to our organisation, as I've said. And we've got some fantastic metrics that underpin, the promotion rates of people who are working. They are not limited from opportunities and ability to move into different positions. We invest in them from an incentives perspective. We invest in them from a career development and training point of view. These people ultimately feed, the hierarchy of our business and the succession plans for the next steps within there. So for us, the principles of most of what's been proposed, certainly around 0 hours, make sense. I think for us, it's really important in the balance to make sure that, a lot of the examples that Paddy's talked to are principally the right thing. But, when you talk around 4 weeks notice to change things and there'll be a cost to that, there will be impacts on businesses for that in terms of their ability to flex around what that looks like. So yes, to answer, in short, I would say that in principle we agree with the things that have been proposed. I think the devil will be in the detail.
Okay, Gregor pointed.
Yeah, Mr. Brown, just to go back a little bit on your answer there, you kind of skated over a little bit on the notice periods. So you talked about 4 weeks, 2 weeks and 1 week. I just want to get nailed down. 4 weeks, you'd start doing your shift roster.
Yep.
2 weeks, you then give staff notice. And then 1 week sometimes as well?
So the best practice is 2 weeks.
Yeah.
We actively followed up at 1 week to make sure that that's been completed.
Okay. What happens when you break that best practice? Do you compensate your workers if you change the notice of the shifts?
As in, if a shift is changed within 1 week? No, we don't. We don't compensate. No.
And so they never get any compensation when you make changes to their shift pattern.
The practice generally is, if something has shifted and changed and we've needed to move something around within that one. Well, frankly, this isn't relevant to the 1 week. Then we would look to try to reallocate that work at another day at another time.
Right, so it's a new shift then?
Yeah.
But you don't compensate at all, ever?
No, not at this time.
Okay. So, and how often then would you say that happens within your business?
I couldn't give you an actual number. I would say it's minimal. As I say, we have the standards in place to enforce or manage to make sure that is the main, the minimum standard that is maintained. Yeah. But I couldn't give you a number, I'm afraid.
And you've got 11,500 people on your workforce that week to week, month to month, might be seeing their shifts changed at 24 hours notice ahead, less than that perhaps. They've got childcare in place, but they're not receiving a single penny from you.
I think, could I say the vast majority of those people would not be experiencing that on a regular basis at all? Right,
but some are.
It's possible. Could I sit here and say 100% no, it never happens, ever? There's no set of circumstances that I couldn't say that. It wouldn't be the right thing to say.
And could you manage your family finances on that basis then?
Well, I understand the challenge. I understand the challenge that's been presented. And as I say, we agree with the principles of putting in some of these protections. We've built many of our own. I accept that this is one that's not live in our business at this moment in time, but we're not sat here saying that these things shouldn't exist and that would be the wrong thing to have. I'm not sat here resisting the view that that might be the right answer. The fact that we don't do it today doesn't mean that we're opposed to the principle.
Right. But you could, though, couldn't you? Because people do.
How do you mean, sorry?
Well, people do compensate. There's
No.
He's talked about some of his
absolutely.
The big businesses, large businesses like yourselves that do come to agreement with their employees. You said that the 0 hours contract staff, employees are really important to you.
I agree.
You could do that. You choose not to.
I'm not sitting here saying that we are perfect and that we do everything perfectly and that we've covered every single scenario. I'm absolutely not saying that. We've done a lot of work to minimise some of the issues that people working in these types of hours, these types of contracts can be exposed to. But that is an example of something that we're not doing at the minute. We could because others do. So yeah, we're not saying that that's something we can't do.
Okay.
Sonny Kumar, briefly.
And you served as a group HR director. How many complaints have you had, or have you had any complaints about 0 hour contracts and cancellation shifts or shifts being given at late notice?
Yeah, so we have a number of mechanisms for people to report issues. We have obviously our formal grievance procedures. That's been, sort of route for the sorts of examples you've raised. The most effective route that we have in place is a direct contact that we have, a programme called Ask Callie. Callie Price, for those of you who don't know, is our workers representative who sits on the board. Callie came from a 0 hours contract background and has worked with the business for a number of years. And she manages directly a communication line from employees within the business. So in the last 12 months, we've had, I think it's 785 inquiries to that hotline, around 400, in fact, let me just quote the right numbers rather than have to try and get them. So 485 of those queries have come from 0 hours contract workers within the business. 80 of those fell under what we would call the category of complaint or concern. 9 of those were related to availability of hours. And Callie's approach to dealing with those is to then, subject to the circumstances, either deal directly with the teams that are leading that and or address the concerns of the individual, so they all hear directly.
So is this in a 12-month period?
Yes.
So you've had 80 complaints about this, and...
Sorry, 80 issues that would fall under the category of complaint.
Okay.
9 of them relating to issues around hours.
Okay, and what's been the resolution for this? So when someone's come to complaint saying, I've given childcare, I've now paid X the child minor, I've paid traffic and travel over, and everything's now been cancelled, or I've been told last minute, and now the fees, the train fees are very expensive, so I'm having to pay an extortionate amount. What's been the resolution to this?
I couldn't give you specifics to that, to that scenario you've just given. What would happen?
Or just generally?
Yeah. So in a scenario like that, where somebody's making that concern, Callie would raise that with the store management to ensure that we are meeting the minimum standards that we set out, i.e., are these people being offered the number of hours that we aspire to, i.e. the 12? What are the circumstances surrounding the reason for the cancellation in the example you've given? I think to Mr. Poynton's point, that it is not a normal scenario where we're cancelling shifts at short notice in our business. And so Callie would look to seek that resolution either in the form of reallocation of hours. As I said to Mr. Poynton, we haven't reached the point compensation for changes.
Do you think there should be compensation?
Look, I agree with the points raised by other members of the committee. I think in certain scenarios where it is, as you know, I've paid for the childcare, I'm in this situation, and that comes about. I think that there is an appropriateness around that affords some of the protections that sit under other employment contracts. I think it's in the detail. What does that look like? What is the conditionality around it? What are the circumstances where it is okay for that to happen? You know, and minimise balance the impact, I guess, would be the ask that I would make.
Okay. Antonia Bance.
Thank you very much. Turning now to your workers at your Shirebrook warehouse in Derbyshire. I think there are around 4,500 workers there. I may not quite be right. How many of those are on agency contracts?
There's roughly around 4,000 people in Shirebrook on agency contracts. It's 1,200 who are directly employed on the site. So we're around about 5,100 people.
And of the 4,000, how many of them have worked there for longer than the 22-week average that we heard REC talk of?
Apologies, I don't know that number.
Do you have any statistics around the length of time those workers have worked on an agency contract at the Shirebrook facility?
Do not apologies, I don't know in front of today. I'd be happy to.
My understanding is that there are numerous employees who've worked a decade plus on agency contracts at the Shirebrook facility. Why do you continue to use agency contracts? Is it a way of ensuring that you minimise your liabilities to those workers?
No. The reasons we continue to use agencies up in Shirebrook is it is a highly competitive area from a warehouse point of view. There are many businesses and new businesses that have opened up there recently. So the competition for talent and the ability to, it's a huge number of people, 4,000 that are required to service the operation there. So we outsource that work to the agencies and work with them to make sure that the standards that that we expect them to have and the legality that they have around how they employ those people is our responsibility to make sure that that's delivered from a service perspective. But it isn't about undercutting our responsibilities. It's absolutely about making sure that we go to the best people who can help us to deliver the right resources to deliver our outcomes.
Yet, of course, the implication of having someone on an agency contract is you can terminate them immediately with no notice.
Of course, that is the potential that exists, but I think to your point, there are people...
And you say there are 1,700 that are directly employed. 1,200, my apologies. Speaking to a predecessor committee in 2016, the Group Chief Executive of your company committed to moving people onto directly employed contracts.
Yep.
How are you doing at moving people onto directly employed contracts? Is it still the policy of your company to move people onto directly employed contracts as quickly as you can?
It is our policy to continue to do that. I don't think there was ever a commitment to say as quickly as we could. I'm not sure that I've seen that in any of the commitments. But we do still action that policy. So over the last 3 years, we have moved 593 people to permanent contracts from the agencies during that period. So roughly 200 a year on average.
Okay. Are you comfortable with that pace of change? And do you think that pace of change will enable you to meet your obligations under the new Employment Rights Bill when it enters into law in the next couple of years?
Sorry, can you be a bit more specific to the obligations?
Are you comfortable with the pace of change of movement of people onto directly employed contracts?
To answer that question at this time, yes. We are currently working through a process of making sure that the people who work within agencies understand the process we have in place and the criteria for that. So we are currently recommunicating that out. But yes, at this point in time, comfortable with the pace of change. Okay. The second part of the question I wasn't clear about.
Don't worry about it. You're on track to report profits of between 550 million and 600 million pounds this year. You've spoken about the respect that you have for the workers and the extent to which they're responsible for your organisation to continue to be profit-making. Why don't you share the proceeds of the profits you're making with your loyal workforce in the form of fixed hours on directly employed contracts, rather than keeping them on agency contracts, which you have yourself admitted allows them to be terminated with no notice?
Okay, there's quite a lot, I think, to sort of respond to in that statement. Ultimately, as a business, we have always been, in fact, lifelong, I think is the terminology we use, believers in allowing our the people who work for our business to share in our success and the success that they help to create. That takes different forms. In our retail stores, we enable people to earn bonuses and commissions related to the performance that they deliver. In our warehouses, we have a number of bonus schemes around delivery and productivity that enable them to enhance their earnings throughout the period. We've just run one recently during our latest peak. So we do believe in the principle that you've talked to. Obviously, you have a particular view of how we best demonstrate that.
I think the point is that only about a quarter of workers at this particular facility are on permanent contracts. And this is a long time after a commitment was made to actually move people onto permanent contracts.
Yeah, I'm not sure that there was a cap to that. I can't talk to the details of that. I apologise. I wasn't around at that time. But as I say, we've maintained that commitment. You know, it is an important part of our operation. You know, the warehouse fundamentally underpins all parts.
Would you accept then it's quite a slow transition to permanent contracts? It doesn't sound fast.
I certainly wouldn't say it was fast. As I say, I don't believe there was a pace commitment that was made, and you know, our ambition is to make sure that people can see a transition and a movement. As I've said, we're committed to communicating that to those individuals. But yes, I wouldn't say it was fast.
And just to be clear, in 2013, 90% of the employees of Sports Direct, and I understand you're now a larger group, but 90% of the employees of Sports Direct were on 0 hours contracts. What is the proportion now?
About 66%, or thereabouts. From a retail perspective, that's our retail workforce.
Thank you. And are you confident you're now meeting your obligations under national minimum wage legislation? The group CEO said to this committee for the first time he disclosed that he was not meeting his national minimum wage obligations in 2016 as a result of the operation of security searches in non-paid time, and as a result of people being unable to leave the facility for their break time, which needs to be their own time.
Yep.
Are you confident you're meeting national minimum wage regulations?
Yeah, if I can talk to you about the changes that were made very soon after our founder made that statement to a committee similar to this. So we have invested heavily in making sure that the bag search facilities and the bottleneck effectively that was causing that issue that resulted in an NMW breach, that has been something that has been in place since 2016 onwards, and we monitor and measure that at all times, and so we're confident that isn't causing any issues for us in terms of national minimum wage.
And the location where people can take their breaks? As a reminder, it can be a breach of national minimum wage legislation. If people are not able to use their breaks as they wish, it then becomes paid time. Can people leave the Shirebrook facility for their breaks?
My understanding is that they can, yes. Yeah.
I'm very glad to hear it. Thank you. In the 2 years to 2015, ambulances were called to the Shirebrook facility 76 times. How many times have ambulances been called to the Shirebrook facility in the last 2 years, please?
In the last 3 years, 4 ambulances have been called to the Shirebrook site. In the last 12 months, 0. I think I would, again, obviously I expected the question. You know, it is something that we're mindful of because of the situation as it existed back then. You know, we've put a lot of time and effort into how we make sure the health and safety of our colleagues across the whole business, but certainly in Shirebrook is prioritised. We have a dedicated team. We've seen the results. Obviously, I've shared with you the reality that it's a significantly reduced number at this point in time. I think it's important to say it is an extremely busy site. You know, thousands of people moving around it on a daily basis. 0 has been a very, very positive year, the best that it's been. But I think the reality is that where there are that many people, inevitably there will be moments in time where, you know, where ambulances are required. Hopefully you'll agree that the levels that we've seen in the last few years are much more acceptable and a massive improvement.
I'm very glad to hear the improvement in health and safety, and that's been reported to me by union reps on the Health and Safety Committee as well. I wonder if you could characterise for me whether you now have a productive working relationship with the Unite the Union, who have representation rights for workers at the Shirebrook site, and whether you feel as though that is delivering for your workers, and whether you have a productive relationship.
Yeah, I think we're starting to get to a more productive place. Up until about 18 months ago, from my time starting in the role, we hadn't had much interaction with Unite as a union for the people that they represent on site. Over the last 18 months, we've met quarterly and have had regular meetings to look to improve the facilities available, the time available for Unite as a union to carry out its representative duties. So yeah, my personal view would be that it is improving.
Briefly.
Okay, thank you. One of the ways in which your workers were at times penalised by the agencies with which you had employment contracts for the staff at Shirebrook was by the use of prepaid debit cards with fees attached that were paid to the agencies to pay those workers. Do your agencies still use prepaid debit cards for those workers without bank accounts, or have they ceased that practice?
I'm not aware that that still continues, but I would have to check to be absolutely sure. I can't believe that that would still be the case.
Thank you. We'll write to you on that.
Final question from me. It may not be my final question, to be fair. But final question from me in this section. My understanding is that you're currently in negotiations around changes to terms and contracts with a set of maintenance engineers at the Shirebrook facility. And in fact, management at that facility have said to those maintenance engineers that unless they accept new, less advantageous terms and conditions, they will be fired and re-engaged. As you will know, fire and rehire is about to be outlawed under the Employment Rights Bill. Are you engaging in fire and rehire at the Shirebrook facility?
My knowledge of this case is that the individuals who are going through consultation with a look to changing shift patterns fundamentally, and also some of the roles and responsibilities have been offered roles that are more advantageous than their current T's and C's as alternatives to the current situation.
Okay, that's not my understanding, but can you write to the committee to reassure us that you are not using fire and rehire, and we will keep an eye on that group of workers?
Thank you very much. The clock is slightly against us, but Mr. Reynolds.
Thank you, Chair. You said earlier, Mr. Brown, about your 4 weeks and workers should be given notice within 2 weeks of their shifts.
Yes, that's
You said exceptionally you do it in 1 week's notice if the manager was off sick.
It was an example.
Is there not somebody else that could do a shift?
To be honest, I'm not sure it was a great example. It was in despair at the moment. I couldn't give you a specific example as to why it was. That's just the standard procedure that we have in place to make sure that we don't find people only finding out, the day before or the morning of shifts that they're being allocated.
You've got a process internally that if it's less than a week or less notice, that gets flagged up on your internal systems.
We have a dashboard that flags through across all of our 0 hours workers arrangements what are the number of hours they're being allocated, and then what are the maximum minimum people they need to employ to be able to make sure we're not offering fewer hours than we should be versus our commitments. So yeah, we've got a decent process.
In the last 12 months, and what percentage of rotas were published with a week's notice or less than your 2 week standards?
I think I said this to Mr. Poynton earlier. I don't have that number to be able to share, but I'm sure we can get that.
Thank you. And you said that your best practice then is 2 weeks. That's what you said is your best practice. Yeah. Then if you're earlier we were told that actually 4 weeks is what they're expecting. So why is your best practice half of USDOR's recommended?
I think probably a difference in view between the two groups of what's appropriate. I mean, ultimately, we I think to Mr. Carberry's point earlier, we aspire to be able to do these things more effectively and further in advance. That is our ambition, to continue to work towards that. So at some point, I'm sure Mr. Lillis's view and my own will hopefully come to a nice meeting point. But at this point in time, that is the standard that we have in place.
If your aspiration is to move towards that place, and that's what you...
to be more effective, yeah, across all of our workforce planning.
And that's what you're working towards to make it better.
Ambition to.
In, say, the last 10 years, how has your shift planning come on then? What developments? If it's 2 weeks now, would you say 5 years ago it was only 1 week was the best practice? Are you moving in that right direction? Or
yeah,
not?
I mean, look, the technology has been discussed as a sort of massive enabler of how we do this. We have invested a lot in how we allocate shifts. Shifts can only be allocated to individuals at availability they've given us, so you can't be given a shift. The system will not allow you to be given a shift if you've not said you can work at that time. Is another one of the protections we have in place. People can swap shifts and reject shifts via the app and then sign that back up. So it all becomes much more effective, much more real time for individuals. I think this begs the question as to I think the point made by Mr. Carberry earlier, the nature of how people want to work in these situations has evolved and is changing. Real time and that flexibility is super valuable. So
to me though, it begs, if we've got all this technology, as you've said, it begs the question to me why you're only doing it with 2 weeks notice rather than 4 or 5 or 6. You know the peaks and troughs, as we've said already, and you know what your budgets will be. You've got to budget throughout your year, your stores have, and your area managers will. So do your area managers only know what the store's targets and budgets are 4 weeks before?
We confirm them that far out, and that is us ensuring that the natural peaks and troughs that come through our business, they've been planned for.
Standard in retail, would you say? It's not standard in retail where I've worked before, having targets 4 weeks beforehand.
Okay.
Would you your career was Evans Cycles,
Yep.
now Frasers?
Yeah.
Would you say that's
Rota planning
in retail?
Yeah, rota planning a month in advance is not exceptional, I don't think.
No, not rota planning, but knowing your budgets and your targets. Yeah. So in my retail background, in my work, I knew my targets. Yeah. I knew what my staffing budget was.
Understood.
For the calendar year.
I understand. And my point is that they are confirmed, and therefore, obviously, we don't start to schedule things and then change them. It comes back to the essence of what we've been talking about in this room. They are confirmed 4 weeks out, and that is the point at which a manager can start to do it.
Okay. Really poor business planning, isn't it?
I'm not sure that I'd agree with that point. I get where you're coming from, given your previous experience, but I'm not sure that that's unique to our organisation as a retailer.
John Cooper.
I think I was very struck by an ONS report which looked at people working on 0 hours contracts, and they said that around 60%, or they found that around 60% didn't want more hours. And we've heard the word flexibility used quite a lot, I think, by most people here. I just, obviously a certain demographic might suit people to have 0 hours contracts, and people on 0 hours contracts are likely to be young, female, or in full-time education. If I could maybe start with you, Mr. Brown, and then perhaps come to the rest of you afterwards. What do you think the likely impact of these changes that the government are proposing are going to be on those people who are on 0 hours contract? Do you think it would change your hiring practices? And perhaps would there be fewer people offered these jobs?
Yeah, I mean, look, the principle, as I think I've mentioned earlier, of the legislation as it's set out is that the 0 hours contracts can be maintained. It gives the right to individuals to request to be given guaranteed hours. So I think it's, the principle of that strikes the right balance. I suppose the slight risk would come around the details, right? What is the cap of that? There is only in certain circumstances at low points in the year there is a number of hours that are required to operate a retail store. That assuming low levels of trade, there's a base that you just need to safely open the shop and operate. Where does the legislation account for what if the number of requests takes hours above that cap? So there are complexities that would have, I think, potentially unintended consequences for individuals in that situation. I think there is a potential for greater levels of redundancy within organisations that currently operate on a slightly more flexible model. Again, if the chips are stacked in a way that means that commercially that's the only way to balance the book. So maybe the two obvious ones that I would call out.
Carberry, concerned there about potential rise in redundancies. Is that something you're concerned about?
Yeah, I think you said earlier on, I think one of the things here is about meeting workers where they are, and there is clearly a group of workers for whom this is what they want. Our survey of I've been told up by the chair by using our survey before, but our survey of temps says roughly half of temps say this is right for me right now. And to give you an example, I went to see the magnificent Paul Heaton recently in Hammersmith and got a message from a prominent FT journalist the next day saying, my daughter served you a beer last night because she was working on a 0 hours contract, and clearly concert attendances do flex, and so I have nothing to say about how they do their scheduling, but that piece about there are groups of workers who are looking for this. And I think as we think about the bill, just remembering that the workforce is not an amorphous blob who all want the same thing, they should all be treated fairly, is really important, because I think it helps us understand where we start. And my most wonkish point for today is we are slightly making policy in a desert here. The Workforce Employment Relations Survey has not been run since 2011. That is the tool that typically tells us the state of employment relations in the United Kingdom. I think it would be wise for government to do one.
Very useful.
Sorry, Mr. Lewis, just very quickly then, you must again also be concerned that a reduction in the opportunities for your members to find work is surely something that is setting alarm bells ringing.
Well, we've said in terms of agency workers should be the peaks and troughs. They should be dealing with the peaks and troughs. We want to see directly employed employees, and the vast majority, and up around the Midlands area was a big industrial hub up there. The vast majority of the industrial sites that we have, most people's employed in direct contracts, and very few agencies used in that. And that's where we would always try to be. Not saying there's not a place for agency workers. We come back to the issue of agency workers having that reference period and not being excluded from it.
Thank you.
Alison Griffiths.
Okay, Mr. Carberry, first of all, many aspects of the Employment Rights Bill will be decided after the bill reaches royal assent. What do you see as the risks of this approach?
I mean, clearly, an approach that leans heavily on secondary puts a significant amount of power in the hands of the Department and of the Secretary of State. I have to say that is kind of traditional in employment law. We've done a lot via regulation in the past. So I think the primary risk is the levels of engagement of the department with the front line in terms of unions and businesses, so we actually can practically work through some of these challenges. I will pay credit to the department. I think they have done a lot of outreach to businesses and trade unions since the election. There have been a number of good discussions. I think most businesses at the moment feel there is a difference between being heard and being listened to. And as we get into maybe some of the more nuggety issues that I think it's fair to say the bill has slightly punted into secondary, that will be the big test and the big risk. So when
give a couple of examples of those.
The best single example, day one, unfair dismissal rights. I think we got a bit lost talking about how long the statutory probation period should be. I'm really interested in how do you sack someone on competence during the statutory period? What's the process? We have history here, and I'm afraid to say both my former employers at the CBI and Antonia's former employers at TUC were guilty parties on this. We created something about 20 years ago called the Statutory Dispute Resolution Mechanism, which was a lawyerly nightmare because we didn't properly test it. So if we think about something like, well, what is the test for dismissal on performance during the statutory period, that's an example where something could go really badly wrong and we end up feeding that incredibly long wait time for ETs, or it could go really well. And I think one of the roles for this committee and for scrutiny of the secondary is just to make sure that those conversations have taken place as the secondary comes forward.
Thank you. Mr. Lillis, same question to you. Possible risks of Employment Rights Bill being, that many aspects will be decided after the bill reaches royal assent. What risks do you see in that?
Well, I've spent my life trying to improve workers' rights and improve legislation that actually helps workers. So I'm, as I said at the very beginning, really, really pleased to see the Employment Rights Bill come in. And yes, it's going to be challenging, but the vast majority of employers working with the BRC, the CBI, the directors, if we work collaboratively together, which we are doing at the moment, we're having meetings on a regular basis with the Department of Trade and Industry. We're having regular meetings with the Treasury Department. You know, we'll find ways to it. I think we're all there to come up with solutions, but ultimately it's about making sure that workers are treated fairly, and it's not just one-sided flexibility. And I would have the opinion very, very clear over the last 15 years, it's been one-sided flexibility. And I say it for this reason, I won't be trying to score points, but I've been a senior official with my organisation for 20 years as a senior official. And in the last 14 years, I've had 2 meetings with 2 Conservative Ministers, Secretary of State for half an hour, and an Under Secretary of State just before the election for about 45 minutes. And that's in 14 years, and you're dealing with employment issues all the time. And in the first, probably, if you use the reference of 100 days, we've had probably 25 meetings with Secretaries of State, Under Secretaries of State, civil servants, etc. And that's the difference. That's the difference, being able to have that sort of engagement, being able to talk through what the issues and concerns are, and working with the employers. I don't want to be causing any more problems for employers, but we need to have it, you know, it has to be balanced on both sides. I think we're starting to get there. So I welcome where we are. I'm not saying there's not going to be sort of concerns and issues, but we'll work our way through them. And the way the government has structured it through the consultation, I think it's working, and it's working really well. And we're starting to find our way through the areas of concern that employers have. So I have areas of concern, I said to you, with the low hours within the bill, I think should be taken out. The regularity should be taken out. there are things that should be taken out of the bill, and we should have the 12-week reference period front-facing in the bill. But they'll all become a matter of these committees in discussion with MPs, civil servants, and hopefully we get to the right outcome.
Okay. Well, that's been an extremely illuminating session. Thank you so much indeed for sparing us the time this afternoon. That's been incredibly helpful in helping us frame our recommendations. But that concludes this panel. Order, order. Appreciate it. Sorry, we're running slightly late. All sitting comfortably?
Yes.
Okay, we'll count down and begin. Order. Welcome to the second panel of the Business and Trade Committee's session today, investigating the government's Employment Rights Bill and the state of industrial relations in the UK. Thank you so much to our witnesses for joining us this afternoon. We know this has been an incredibly busy period for you over the Christmas period, and we're really grateful to you for your time in joining us today. Mr. Martin, perhaps I could start with your good self. The UK has obviously got a range of employment options. You've got employees, you've got workers, you've got self-employed. Is that flexibility basically a good model in your eyes?
So first of all, thank you for inviting me to talk to you this afternoon on this really important topic. We believe the flexibility offered by the middle status, this LIMBY worker status, has got great potential and could be used more. It was created to give more rights to self-employed people as opposed to weaker rights for employees. The status as it's defined at the moment is quite restrictive. It applies to people who don't have an employment contract, but the relationship is such that it's close enough so it's not actually a true client and supplier relationship. That's usually because the level of control exerted over the worker, and crucially, because that worker gives personal service. So they don't have, or they have a very limited right of substitution, ability to bring in someone to provide the services for them if they're unable to carry out themselves.
The basic structure of employee, worker, self-employed, you think that basic structure and system is good?
I think if you could reform the middle status to make it more accessible, it would be greatly, it would be used far more greatly, and would provide a more meaningful level of flexibility in the work in the labour market.
So in 2022, you rebranded to Every and you refreshed your core values. And number one, the first of those of core values, it says, do the right thing for our people. Do you believe a word of that?
Absolutely.
So we have been inundated with feedback from whistleblowers ahead of this session. And let me just read you some of what we've heard. So let's just start with wage discrepancies. One person has written in to say the figure of £15.61 per hour, which was stated to the committee 3.5 years ago, is, quote, completely unrecognisable to most couriers. Parliament has been misled several times by this company. Another wrote to say rates vary vastly in couriers doing the same sort of rounds. One courier's parcel rate could be over 15% higher than another. Another says new couriers are not always told their rates when they start. In reality, the majority of parcels are packets and paid at 75% of the standard rate. Another wrote in to say one of the persistent practices is to agree a round rate, then change the goalposts. Another wrote in to say Every is renowned for their computer system that never gets anyone's wages correct and robs thousands of pounds off couriers every month. There's no telephone contact system to fix things. Is that doing the right thing for your people?
I have to say I don't recognise that evidence. We do pay couriers on a per parcel basis. Those rates are calculated according to the sort of geography of the area in which they're delivering. So it's basically the number of parcels they're able to deliver in an hour, because we model that to make sure that couriers earn well above the national minimum wage, because we want our couriers to continue to deliver parcels for us. So 60% of couriers have provided services for more than 2 years, and 20% more than 5 years, and 13% more than 10 years. So we believe that sort of really evidences a model that is fair and sustainable, and couriers actually, enjoy and are well remunerated for.
Well, let's
for
move on
to
another bit of evidence that we received, which says that in calculating the hourly rate, the company doesn't take account for the courier's extra costs or for the time spent scanning, sorting and loading times of parcels, the time taken to repair damaged parcels, and the time waiting for late vans. So how confident are you that you are actually honouring minimum wage legislation?
So our model is audited on an annual basis and reviewed by our trade union, the GMB.
They only represent some of your workers?
They are a recognised trade union for our couriers. So all of our couriers can join them and be represented by the GMB. They look at the model with us. We do model for time taken scanning and delivering the parcels. So the time will start when a courier first scans their first parcel to receive it, and then it'll end on the last delivery. So we measure that time, and we know the number of parcels delivered in that time period, and we're able to calculate their earning on a per hour basis.
Well, let's move on to what some couriers describe to us as the packet racket. They said to us the mislabelling of parcels issue appears to have resulted in several £million being ciphered off courier pay over the last 8 years. Another said, I find 10% of the parcels I have to deliver are incorrectly banded. Another said, we're allowed to claim for misbands, but a proportion of our claims get rejected. We're not allowed to appeal rejections despite photographic evidence. Most couriers don't claim as it's time-consuming or too much hassle. Another said, every claim their volumetric scanners are accurate. Nothing could be further from the truth. Is that doing the right thing by your people?
The term packet racket has been used for a long period of time.
It sounds like it's still in force.
We've done a lot. We've really done a lot over the years to improve the accuracy of.
These emails came in at the end of last week.
I have to say, we work really hard to measure and capture the volumetric and the weight of all of our parcels. Couriers are able to, if they think they are wrong, take a photo, and actually we will pay out on, we'll upgrade where it's an incorrect parcel if the clients have articulated or given us the wrong data. But we will weigh and capture the volumetric data of over 80 to 90% of our parcels. So we are paying on that audited rate where it is higher than that notified to us by our clients.
But it sounds like there are some flaws in the system. But let's move on to unachievable targets and wage reductions. Another whistleblower said to us, every sets targets that penalises couriers for working efficiently. For example, If a courier delivers more parcels than expected, the pay rate is reduced, creating a cycle of underpayment. Is that doing the right thing by your people?
As I said, we are very careful to model the number of parcels that are delivered by our couriers and the time in which they deliver them. And we ensure that those those rates will have earnings far greater than national minimum wage. And that is a model which is, reviewed on an annual basis with our trade unions. So I don't recognise those statements.
Okay. Well, let's move on to the allegations we received about unfair competition and practice. But the focus of this complaint was I'm quoting again, every 27p per mile allowance for couriers is insufficient to cover the cost of vehicle ownership and maintenance. Is that rate doing the right thing for your people?
That's a rate which is modelled on HMRC's per mile expense rate. So we thought that was a fair risk rate to use.
Okay, well, another set of complaints was around poor treatment of workers and the health and safety of various facilities. So one person wrote in to say, over the peak period of December, many couriers are forced to work 27 days without a day off. Another said, if they don't work on these Super Sundays, they have to deliver the Sunday parcels on the Monday and Tuesday. This, quotes, is physically impossible. Another has spoken to couriers who said they were already working from 8:30 to 8 p.m. non-stop, delivering Monday to Saturday. When they informed their manager that they were physically unable to do the Super Sunday, they received an improvement notice for being unable to take the Sunday parcels on the Monday. At one depot, we were told fire exits are frequently blocked, cages with metal wires and spikes were protruding dangerously. Some depots have no toilet facilities or access to hot water. Is that doing the right thing for your people?
We have a set of requirements for all of the delivery units into which we will deliver the parcels and the couriers will collect them. All of those requirements have operational toilets, hot water facilities. We do audit and check those delivery units. So I'm confident that that sort of statement around health and safety and blocking fire exits is not accurate. We do check that. Our employees are in these sites regularly throughout each week, so we would know about it. Our health and safety teams go and audit these sites as well. So I have to say, I'm afraid I just don't accept that.
Okay. Well,
in terms of Super Sundays and working long hours, parcel volumes will double over that sort of Christmas period. We took on 10,000 extra couriers to be able to handle that extra parcel volume. Where couriers are unable to collect all the parcels, the delivery units are kept open to allow them to come back and deliver them throughout the day. And they're, of course, able to bring in other people to support them.
Well, let's then look at unfair use of self-employment. So another set of complaints that we received into the committee's team was that Every has main depots that employs sorters to sort the parcels, but they're then transported out to sub-depots. And when it comes to the sub-depots, these are contracted out. And so each sub-depot has its own local contractors, which treats the sorters as self-employed rather than employed. Is that doing the best thing for your workers?
So, we've not used the terminology sub-depots for a long period of time. They are, though, in the main, contracted suppliers who will run the site, have their own people carrying out the sortation of the parcels for the couriers.
Okay. Well, there are then further complaints around exploitation of vulnerable workers. So subcontractors were reported to be using those in the country illegally, and people who were claiming benefits to cover delivery rounds. And they were told that Every allegedly turns a blind eye to these practices. Another talked to us about lack of proper courier checks, not currently checking the background or insurance status. And then there were many complaints around couriers who were raising issues with Every management and basically just being given a cold shoulder. Is that a good way to put people first?
So, I'm really sorry to hear those statements.
Well, I've got lots of them.
And
you know, I've literally got pages of whistleblower complaints that have come in as soon as people found that we were running this session.
We do have a code of conduct which is on display in all of these delivery units where the couriers will collect their parcels from, which clearly has a anonymous whistleblowing number on it as well as my email address, as a company secretary email address, so they can write directly to me and my team will investigate. Our employees are on the site. If they have any issues, they can raise it with them, and they can raise it with the GMB representatives that are within these sites as well. So we have lots of ways in which we can gather in these sort of claims. And I have to say, these are not things which I recognise or brought to me directly from couriers or the GMB.
When I put the list together, wage discrepancies and inaccurate payments, unfair use of self-employment, unfair practices in parcel funding, unachievable targets and wage reductions, unfair competition practices, poor treatment and health and safety issues, bullying and intimidation, exploitation of vulnerable workers, lack of proper courier checks, failure to address couriers' concerns. What workers and couriers describe to us is not a partnership agreement with Every. They describe a slave driver's contract. And so I'm curious as to how you're not picking this up when our inboxes have been flooded ahead of the session.
I'm also curious of that. We have numerous, as I've mentioned, numerous ways in which couriers can flag any issues to us. In addition to that, we have we survey our couriers twice a year to find out what their sentiment is and to take any feedback.
None of these 10 issues came up.
Not that I'm aware of. No. I mean,
something appears to be going wrong on the shop floor.
Our couriers will have frustrations around the services that they provide. Things like
it's their fault. It's the courier's fault.
No, things like parcels not being delivered or being available for them when they arrive at our delivery units for collection. That's the sort of typical issue that they will face, which we work with them to try and solve. But but we don't always get it right. But as I said, there are numerous ways in which our couriers can tell us how they are being treated, and I have to say, I just don't have those emails flooding my inbox.
Well, we do, I'm afraid. So, with the new Employment Rights Bill, how will your model need to change? And what will this conversation feel like in 12 months' time once the bill's gone through, do you think?
Well, so the employment bill at the moment we're supportive of it virtually in its entirety. We work hard with our trade unions, the GMB and USDOR, so we're supportive of the trade union elements of the bill. We're supportive of flexibility from day one. We have that already within our employee network. And day one rights we're supportive of, and as with a single enforcement body, we were very supportive of that. So the bill at the moment, we don't have any concern about at all. There will be a consultation on employment status, which we will feed into, which we wrote. We gave some written evidence to your committee about as well, in which we were invited to give you some evidence today on. We believe that our model, which is based upon the flexible MB status, grants paid holiday, union recognition, pensions, these are rights which our couriers have today and which we think can be rolled out more widely to organisations that use self-employment at scale.
Do you think that your couriers have strong enough rights today?
Our couriers have numerous ways in which their voice can be heard.
But do they have strong enough rights in the workplace today?
They have paid holiday, union recognition, pensions, and soon to have a sick pay scheme, an insurance-backed sick pay scheme, which has been agreed with our trade union.
Do they have strong enough rights at the workplace today?
I believe so, yes. Coupled with the level of flexibility that couriers like to have to be able to access work and provide.
So I've just read you out a long list of 10 whistleblower complaints, but you think that they've got strong enough rights at the workplace today?
I'm unsure as to how those whistleblowing complaints could be sort of enforced. You know, we would, if we heard about them, we would investigate them, of course. And if their pay rates were paying less than our model, we would take action. Where couriers find parcels which are an incorrect size to which we are paying, they can tell us about it, and we will change their rate, that rate that they are paid for that parcel.
Thank you. Antonia Bunce.
Thank you very much. Turning now to you, Mr. Bedford. So there have been reports that Deliveroo riders are subcontracting their accounts to workers who don't have the right to work in the UK. Do you have any concerns that substitutions are being used to exploit vulnerable workers?
Thank you for having me. I think on the point around substitution being used to allow people without the right to work in the UK, that is an issue that I think has been flagged to us, both as a company and as an industry. You may have seen that we met with the Home Office, I think almost a year ago now, to discuss the issue where immigration enforcement officers talked to us about the issue they'd started to find within the sector, potentially of substitution being used to allow people without the right to work onto platforms. We committed last year to introduce measures to essentially prevent people without the right to work being able to access the platform, and as Deliveroo we've led the industry in introducing the sorts of technical changes that will prevent people without the right to work accessing the platform. So last April we introduced registration accounts for substitutes, so substitutes for the first time needed to register in advance before they could complete deliveries. That also allowed us to undertake the right to work checks directly on those substitutes. To police that system, we've also improved our facial recognition check technology, where essentially now every single day that you log into the platform, you're required to take a video selfie as the rider. That means we can check the video selfie that's provided on a daily basis with the documentation we've got for the main account holder or for the substitute. So in essence, I think this had been flagged as a sort of small problem for the industry as a whole. We've then led the way as a company by introducing these measures, and I think that had been recognised by the Home Office and is something that we're very keen for our competitors to also introduce at the same pace and scale that we have.
But why do you continue to allow substitutions of riders when it has been so very well publicised that it's open to abuse? Surely it would be easier just to take away the right for people to nominate a substitute, and then you would be confident that you weren't contributing to an illegal market in inappropriate working.
I think first off, it's worth saying that substitution is just a sort of normal, regular part of self-employment in the UK. It's not specific to our company or our sector. There are lots of different parts of the economy where self-employed people have the right to substitute. I think I'd also say that simply just removing in law the right to substitute won't prevent people who want to break the law from abusing it. We're dealing here with people who are trying to sell their accounts to people without the right to work, so they're already doing something they know is wrong. I don't think legally making it illegal would be something that would necessarily deter them. The way to stop people trying to abuse our system is to actually introduce robust technical measures that we've done to actually stop them doing that and to destroy that secondary market of people trying to sell accounts to people without the right to work. So now they've got to register their substitutes, and there are facial recognition checks taking place on a daily basis to make sure that the person who's registered is the person on that account. That's the way to solve it, and in doing so, people who are legitimately using substitution, which again is a normal part of self-employment in the UK, can carry on using that, and you're not taking away the rights that they are enjoying as a self-employed individual.
The other way, of course, to deal with the issue of inappropriate use of substitution is for the employing company to recognise that its workers are in fact workers rather than self-employed. Why do you continue with this idea that these workers are self-employed rather than workers with a responsibility to your company who are under the direction of your company?
So I think I'll happily set out how our model operates and why it is self-employment and why the Supreme Court has found our riders to be self-employed. So I think it's worth stating up front, our model has been through the courts, and the Supreme Court were clear that this is a model of genuine self-employment. It's not a case where they have reclassified them as workers, as is the case with other companies you may have seen in the gig economy broadly. But if I set out how we work with our riders and how they operate and why that is self-employment and contrast that with worker or employee status, then the first thing to say is once you've registered and are online on the platform as a rider, there's absolutely no obligation for you whatsoever to hold yourself out for work at all. So there's no requirement set by Deliveroo that they have to be available for work at any period of time. Our riders can choose when they want to log in and they can choose where they want to log in. If I kind of contrast that with a worker or an employee, clearly the company they work for determines when they start their shift, where they have to turn up. There might be some negotiation about whether they get certain days off or can start late, but ultimately the company has the final say on when they start and where they start. For Deliveroo, that's not the case at all. It's entirely in the hands of the genuinely self-employed rider. Once riders log on, if I take the second part, they'll be offered work and they'll see when they're offered work where the collection point is, the shop or restaurant, where the customer is they need to drop it off to, and they'll see the fee that they'll get paid very clearly up front. They then have the choice to accept or reject that offer of work, and they can reject every single piece of work we ever send them, and that has absolutely no consequence whatsoever on their standing. So there's no requirement for them to accept a certain number of offers that we make them. They can just go through rejecting every single piece of work we offer. If I contrast that with an employee or a worker, clearly you can't refuse the task that you're being given as an employee or worker. If I were working in a supermarket, I couldn't say, I don't want to stack that shelf, but I'm happy to go off and stack that one with my manager. Again, I could negotiate about the tasks I do, but the final say is with the company about the tasks that are being performed by the worker in that case. And then the final point to talk about and to draw your attention to is the fact that our riders can work with competitors at the same time as working with Deliveroo. So you'll find when our riders are working, they'll quite often have competitor apps open at the same time and be choosing and selecting between different jobs that are being offered across multiple platforms. If I contrast that with employees or workers, clearly they can't be working with competitors at the same time. You couldn't expect a McDonald's sort of chef to think, service is too heavy, I'm going to go down the road and sort of go into Burger King and start cooking. So that's the sort of very clear difference between our self-employed model and the sort of models that exist in the employed or worker status bits of the economy, and why the Supreme Court were very confident to find that our model was genuine self-employment.
Joshua Reynolds.
On substitutions, you've said that you've introduced this selfie verification to make sure that people aren't substituting when they shouldn't be. Do you think a selfie is enough to stop criminal gangs from exploiting people in your platform?
I think it's a very robust control. It's a video selfie.
Do you really?
I do, because I think you're required to take a sort of moving selfie that's then compared against the documentation that is held on file. So yes, I think we have introduced market-leading robust controls that if you go into the slight rabbit warren of online rider chat forums, you'll see, and we can happily send examples of these discussions, people talking about the fact that our controls are having an impact and are robust.
Your rider website says that if you allow substitutes to complete orders on your behalf before the verification, then your account, the rider account, will be terminated. How many rider accounts have been terminated because of something like this?
So if I give you the numbers, and I'll put it in the context of our overall active fleet, since we introduced the substitute registration feature, we've had around 6,000 substitute accounts registered. That's about 5% of the total number of riders we've got, just to give you some context. So that's the number of substitutes. We've stopped around 2,500 accounts from going, or the substitute accounts from being kind of finalised. That number, and we don't have the breakdown internally, but that will include people who started the application process and didn't complete it because they just decided they didn't want to. It will also include people who failed the right to work checks. Some examples I've seen are where people were applying with the wrong visa type that wasn't permissible under the self-employed scheme. So, but in total, so therefore not all of that 2,500 are people who failed right to work checks, but it will include a proportion of them.
That might be the case, but how many accounts have you terminated because the rider has allowed somebody else just to go and take their app or log into their app and deliver on their behalf?
So where we find people abusing it, we will terminate. I don't have a specific number of beyond that 2,500 figure where people have started that substitute registration process and have failed, and therefore that has been stopped. But again, we can take that point away on specific numbers of accounts that have been terminated if they have been found to be breaking the law.
What's to stop me, for example, from giving, if I was a delivery rider, what's to stop me from giving my app or giving my phone to somebody else and going, you can complete my orders today?
I wouldn't recommend giving your phone to other people, but I think if you were, if you sort of were trying to do that to get around the facial recognition checks with the software, again, I think you'll find that you'll be required to take a selfie within every 24 hour period.
So I could do that, couldn't I? If I lived with somebody that didn't have the right to work in the UK, I could log in at 9 o'clock in the morning. I could do my video selfie and give my phone over to somebody else for the day. They could complete shifts on my behalf, work illegally, and then give it back to me that evening, and I could do the same again the next morning.
I think that would be difficult to achieve with the timing of when our facial recognition checks would necessarily take place. So I think it would be complicated. But I think if we think about where we were as in...
How would it be complicated? Sorry, if a facial recognition check came up, for example, could I not just close the app and go home for anything?
No, until the facial recognition check has been completed, you won't be able to complete delivery. So I suppose logistically... I think logistically, that example, you'd need to be with the person clearly, or you need to be in very close contact for that sort of thing to happen. So I think if you were trying to just sort of sell this to someone else because you wanted to make money, this would be challenging because you then clearly need to be in close proximity to them every 24 hours.
But I think if we living together in a caravan camp outside Bristol, for example.
I think if we look at where we've moved as an industry and as a company, we've introduced these checks and they are significantly more robust in addressing the problem of substitution. We'll happily take away that point around can they be made even more robust. There are additional controls that we're introducing this quarter to make our process even more significant. So it will also trigger a facial recognition check if the app detects a different device is logging into it. So in the example, if you were to do the facial recognition check, log out, and then someone else tries to log in on their phone, it will then trigger a second facial recognition check to try and prevent that sort of abuse. Those are the checks that we're continuing to roll out. But I think, again, if we were to step back, as a company, we've moved significantly far in clamping down on this problem. There is evidence online in wider forums that shows these are having a positive impact. We've gone further than our competitors in the UK and would want our competitors who aren't on the panel to introduce the same sorts of measures that we've taken. Take your point that if criminals really, really want to get around stuff, they will find ways, and we need to be vigilant to that. And there are things that I think we can and should continue to do. The device ID login change is something we're introducing, but of course we will take away the point about how else we can make this as robust as possible.
Okay. Weston Griffiths, did you want to come back in on that point? I think you were about to say that you weren't 100% sure that your competitors had the same kind of robustness to their checks.
So they don't have the same robustness of checks as I currently understand it today, and I think in our conversations with the Home Office and as recognised by the Home Office, Deliveroo had gone further and had led the industry in introducing these sorts of measures.
So if the Employment Rights Bill was amended in ways that began to introduce a different kind of regulation to self-employment, perhaps changing the balance between some of the definitions of when somebody was self-employed and when perhaps they were an employee and a worker, how would you respond to that?
I think we would... It depends entirely on, I think, the terms in which status changes were being discussed. I think the point we tend to make in this is that we're offering a form of work that is incredibly attractive to a lot of people and is drawing in a lot of people to the labour market who otherwise wouldn't participate, because this form of fully flexible work allows them to work, earn and pay tax. I think our position generally is that flexibility needs to be protected. Of course, there's a debate to be had, and a genuine debate around the sorts of protections and benefits that genuinely self-employed people get. And I think we would welcome a discussion in the course of the consultation on status that looks at the benefits and protections that genuinely self-employed people have. So I think if that was a discussion, the way it were framed, I'd welcome that and think that would be a good step forward, something that we support and something that the GMB who represent our riders would also support.
And in that consultation on single status, where do you think there could be, from your company's point of view, room for improvement in today's regulatory regime?
So I think the first step, and this is not necessarily linked to single status itself, because that's clearly merging worker status and employee status, which on the face of it wouldn't affect our riders who are genuinely self-employed. But I think as part of that discussion, if there were steps that could be taken to allow companies like us to provide additional benefits and protections on top of the things we already provide, that I think would be a very good first step. We unilaterally as a company provide insurance-backed sick pay and parental payments. That's not something that self-employed people clearly get as a right, but it's something that we offer because based on discussions with our riders, it's something that they find valuable and makes our proposition more attractive on top of the flexibility. So doing more things like that I think would be a good step for the bill to allow us to go further.
Thank you very much. Very good point.
Great. Mr. Dudek, what motivated Uniqlo to hire freelancers over agency workers to manage your Christmas period?
Well, thank you very much for having me here. And perhaps not everyone might know Uniqlo, so allow me to just give some context. We've been in the UK since 2001. We have 20 stores.
We are fully briefed on Uniqlo.
All right.
You can cut straight to answering the question.
Yeah, so to put it in perspective, 99.5% of our workforce is directly employed, and all those colleagues, they are guaranteed hours. To answer directly your question of why have we gone that route, it was a trial, and the main purpose was we were struggling to staff some of our regional stores. That trial totaled 3 weeks from the 26th of November to the 15th of December. It was a total of 22 shifts for 165 worked hours. In context, Uniqlo last year in the UK, we worked 1.7 million hours, our colleagues. So I just want to make sure that I stress the fact that it was very short in time and also in length, and it was coming out of a need of fulfilling some staff shortages that we were identifying in some of our regional stores outside of London, where the accessibility of talent isn't as readily available. But we stopped.
Yeah, so that doesn't really answer the question, because the question was why freelance over agency? Because we understand, you need to manage busy Christmas peaks. There are staff shortages in certain parts of the country and so on. But why freelance over agency?
As a business, we're always trying to find new ways to bring people in our company, specifically for the areas where we trialed this. I just want to emphasize that this trial was not for all the stores in the UK. It was only specific to areas where we were struggling to find talent with our existing channels, which is obviously direct, but it's also we are working with a normal agency. We couldn't find enough sufficient talent to gap. It was a peak season, which
you couldn't get enough people through agencies, so you tried freelance.
Precisely.
Okay. What were the paying conditions for those freelance workers? The paying conditions for those freelance workers?
They were
How do they compare to the permanent staff you talked about?
Exactly the same. So the salary that we offer to the freelance workers are exactly the same salary that we offer to our own employees that are directly employed from us, and that is the real living wage both in London and in suburban areas. Did that answer your question?
It did.
Sorry, what was their entitlement to holiday pay? If their terms and conditions were exactly the same as your directly employed workers, what was the entitlement of your freelance workers to holiday pay?
Sorry, ma'am, perhaps I misunderstood. The question was about the wage amount.
No, the question was about
what are the we're interested in understanding from the full range of benefits that are offered to full-time employees, what was the package that was offered to freelancers? Was it 100% the same, or were there differences?
So when we hire directly, we offer a wide plethora of benefits, specifically maternity, paternity leave. We offer holiday entitlement. We offer bonuses as well. For specifically, the reason why we stopped this trial is precisely because we want to make sure that we focus on our talent internally, and that we could offer the full plethora of our benefits to the people that we employed. So once again, we decided after the short trial that it's not for us. We do not, at this point, we will not use this methods of employment anymore. And again, I just want to stress that was a very limited in time and something that we do not wish to continue, and that's why we stopped.
So if I get it right, the pay was the same, but the other elements that we talk about, the benefits, the full plethora of benefits, they didn't get those. They got the pay, but they didn't get everything else.
I think that specifically when we talk about agency workers, they do enjoy the same benefits we offer for the freelance workers. For the details, I would like to follow up in writing, as I do not want to give the incorrect answer, Chair. I apologize.
You had the trial. It was a 3-week trial.
We stopped it.
You stopped it. What went wrong?
So I think from our perspective, the difference with the freelance worker option versus hiring directly, and also the agency workers, is the availability of talent. So the freelance worker does not guarantee hours for specific shifts, which is defeating the purpose of the entire enterprise, because we started this trial to fulfill specific gaps. At the same time, we were also receptive to inputs from the stakeholders, and we decided that based on the value that we have a company, which is to really nurture talent internally and really promote development within our company, this was not the right fit for us in time at the moment.
Yeah. Now, you mean your statement, I'll just read a little bit from it. Uniqlo no longer sources freelance workers for temporary store-based roles. We instead recruit for our temporary and permanent positions directly or through other channels to ensure all our staff are eligible for applicable employment benefits. We're committed to treating our employees fairly while maintaining our high service standards, which all sounds good, but that does sound to me like in that period, those high standards were not being met.
I think perhaps, if you allow me to rephrase, this freelance workers were not utilized on the shop floor. They were utilized in tasks such as, for example, restocking. And the main purpose of this exercise was to allow our employee to serve the customers and maintain those operational standards and customer service that we pride ourselves into. So perhaps to summarize once again, we do not believe that this method, this model works for us. That's why we decided to discontinue it. And in this moment in time, we do not wish to work in such a way, and that's why we stopped it.
And then I suppose then more broadly, as you said, that model doesn't work for you. Just be interested then on your views on, do you think we need clearer regulation around the gig economy, given the experience that you've had?
Well, as a global business, we operate in 26 countries, specifically 11 countries in Europe, continental Europe, where some of the proposal of these legislations are already in place. I mean, I myself have managed the Italian business and also the German business. We've been successfully operating in those legislative framework. So I believe that the suggestions that are included in this bill will obviously, as the chair mentioned, make work for the people here. So to answer your question, whatever the decisions of the committees will be, we welcome it, and we will make sure to stand by that legislation and fully be compliant. At the same time, as I mentioned earlier, already in the UK, we go above and beyond the statutory framework. We pay real living wage. Even just a few months, last summer, we passed 6 months paternity leave for our entitled employee. So again, whatever the committee will decide, we will make sure to adhere by.
Okay. Reynolds briefly, and then Antonio.
One of the benefits that Temper claim on their website for using their platform is that you can, as an employer, you can cancel a shift 24 hours before the start of their shift. When you were using their platform, did you take advantage of that feature?
I would have to check. Apologies, I do not want to give the incorrect information. I'm not aware of it, but once again, let me come back to it. Because of the very small nature, 22 shifts, I would not imagine so, but let me get back to you.
This trial was quite a big thing for your business, I'm assuming, to try and, potentially, could it work? So it was a big ordeal for you to try and go through that trial, which took a long time, I'm assuming, to get right.
I wouldn't call it it was not a strategic choice. I think, English is not my first language, so perhaps I haven't explained it myself. It was a way to try to fill the gap in some of the stores outside of London. We were really struggling to find talent, and it was, as a business, and again, I heard in the session before that yourself also worked in retail, we're constantly looking for opportunities to bring in new people. We are trying new things. This particular experiment came to an end because it just wasn't.
You've been the Chief Operating Officer since 2019. Were you involved in the experiment at all? Were you involved in the decision to use temper?
Was it as
you personally, as Chief
Operating Officer? As every decision we make in business, it's a collegial effort, and we decided to trial as a way to.
I get that, but were you specifically involved in the decision to make the trial? That yes or no?
I was involved. Yes.
You were involved. So you obviously made the decision then to say that you struggled to find employees at your salary, at the right salary. So you thought you would go via this company to try and find it. So looking at one of your jobs that you've got online at the moment, they're paying £14.15 an hour in one of your stores. Temper take £3 an hour as a fee that they add on, that you pay them. Did you try recruiting staff at £17.15 an hour before you tried going with them?
Honourable Member, I'm not very familiar with the details of what you're mentioning. I apologise. Yeah.
Looking at their website, it says that using Temper as a platform, you as an employer pay them £3 per hour as a fee for every hour that's worked. You're currently recruiting staff at £14.15 per hour. So before you decided to use this company of freelancers, did you try recruiting staff at that elevated salary?
Again, if you don't mind, if I can have the specifics of what you're mentioning, and then I can assess the full situation.
On their website.
We can follow up in writing with you. The point is, did you ever try recruiting people at £17.75 an hour before deciding to use Temper?
I mean, is this an hypothetical or is this specific?
No, it's real.
I mean, specific questions. We have different salary tables, salary grids, meaning that when you enter the company, you are paid at the real living wage, and that's the threshold. As you progress, and I believe that's the same situation in every business, you gain more seniority, and so does also your salary levels increase. So you're asking me if we would hire people at a higher grade doing for the same job that they would do somewhere else?
Yes,
I mean,
that's what you're paying too. So rather than paying a middleman the £3 an hour that you had to pay as a company through Temper, which I'm assuming, as you said, you were involved in the process, you probably knew that you had to pay them as a company to find these people for you. Rather than giving that money to them as a freelance agency, why didn't you just give it to the employees?
I mean, Chairman, Honourable Member, this £3, I apologise. This is
we will set this out in writing.
So I really do not want to mislead anyone, but I just have not heard of this information.
Okay. Antonia Betts.
Thank you very much, Chair. So, when I worked in retail, both in the back room and when serving customers, as a directly employed employee, I was expected to follow the instructions of the store manager. Were these workers employed through Temper expected to follow the instructions and complete the tasks assigned to them by the store manager or another manager in that facility?
So specifically, these workers, as I mentioned earlier, they were working in the back of house. They were working shelving. So for all intent and purposes, just putting products in the shop floor to allow our custom advisors, as we call them, to then be able to directly interact with our customers. The directions throughout the day would be something that the store manager on site would then allocate to the workers themselves.
So if there was a store manager on site who was performing task management and allocating tasks to these workers, in what sense were these workers self-employed?
Honourable Member, I think perhaps when it comes to evaluating the job worker status, I think this is something that is left to an expert. This is beyond my remit. As I mentioned before, the trial with Temper is something that we have decided to try to fill a gap, but we also decided to stop because it was not working for us, and that's why we decided to discontinue it. So I think that, apologies, I think the reason we're here today is because we want to find new ways to ensure the flexibilities that our workers, but also companies want, in a way that still protects their right. So to then answer your question, I don't feel I am the right person to comment on worker status, and apologies for that, but I want to reiterate the fact that in Uniqlo we are committed in making sure that our staff feel supported, they have a clear career path to success, they can grow inside the company, and that is once again why I want to reiterate the fact that 99.5% of our team members are directly employed, they are guaranteed hours, and they see a path to success.
No, we appreciate that point.
So you're not totally sure whether you were in compliance with relevant employment law when you engaged these workers via temper. I'm very happy for you to write to me with the results of your compliance on that point.
Thank you. I think we will avail ourselves of.
The challenge is, from your description, it doesn't sound like they were genuinely self-employed. That's the problem we're having.
Yeah.
Mr. Chair, I think for the specific of these questions, and again, I want to apologize if perhaps I'm not understanding fully what the content of this question is. I would like to follow up in writing.
Thank you. And so, do you feel that you made a mistake working with this app?
I think as a business, and I think many of the members here we're working in a business, it's only natural to be looking for opportunities to continuously bring new talent into the company. We realized that this trial, after the trial, that this was not working for us, and that's why we decided to stop. Again, it is our opportunity to continuously try to find new ways to have that talent. And this conversation really will help. It's also helping us guide our actions and understand how we can best contribute to the workplace here in Great Britain.
And did it become clear that it wasn't something you wished to pursue before or after there was media coverage of the reputational impact on your company for using bogus self-employed workers employed through an app?
So the trial, again, for transparency, the trial ran from the 26th of November until the 15th of December. So the duration of the trial was always established, and the locations of the stores were selected. As I highlighted before, it was always meant to be a trial, and then we were able to reassess. That trial only ended up in 165 workers' hours and 22 shifts. So once again, we decided that that was not the right fit for us, which doesn't mean that it cannot be the right fit for other businesses, but for us specifically, we believe in fostering growth of employees directly, and that is, again, why 99.5% of our employees are employed directly.
And sorry, you took the decision not to continue with the trial before or after the media coverage?
Perhaps if we know exactly when the article was published. I don't have that information at hand. I am sorry.
Yeah, that with you. Okay, thank you. And finally, Mr. Cooper.
Thank you. Temper, it's a strange sort of outsourcing. I don't know if you could tell me. I don't know. I'm not familiar with this. Are there many of these sort of apps? Is this a thing that's growing? Are they the only people in this market, or are there several like this? Do you know?
Honourable Member, I feel I can only comment on what I personally know. So I'm not very familiar specifically with the other options that are out there with freelance workers. So I apologize. I'm not. I don't have any further comments on this particular topic.
And you were involved in the decision to try and go down this route. How did you come across Temper then? Did you seek them out? How did it work? How did you come across them?
So for the specific of selecting this particular suppliers, I would like to follow up in writing, as as I don't have the specific details of that search. So please allow me to follow writing.
Okay, and again, I don't know if your background is particularly in the law, but did you run the rule over this? Did you look at the legality of this? I mean, obviously the company appears to be a legitimate company, but there do seem to be sort of grey areas here. Would I be right in saying that?
Well, as a company, we only work with certified suppliers, and we also have a code of conduct on which they have to adhere. So, again, for the specifics and for the purpose of being clear in this committee, allow me to follow back with concrete answers.
Okay, thank you. Thank you, Chair.
Very briefly, Mr. Reynolds, very briefly.
Thank you, Chair. Something doesn't quite add up for me, though. You're the Chief Operating Officer of this organisation, and you don't know of specifics of a trial that you've told us already you helped to introduce. I'm really confused. Help me make that make sense.
I think perhaps if you can help me understand what are the specifics of this question.
So you're the Chief Operating Officer of Uniqlo. Yeah. I would imagine as an individual that meant you were all over your business. You knew exactly what was happening in your organisation. You told me earlier that you were part of the decision-making process to start this trial with Temper. But you're now telling us you can't tell us the specifics because you don't know them. Do you not know what's happening in your business?
Mr. Chair, with all due respect, I think that for the specifics and for the sake of clarity, I would want to make sure that whatever information we're providing here is fully accurate. Again, I do not want to mislead anyone, and I want to be clear. Again, we're very happy for the opportunity, but I just want to make sure that we're providing accurate answers.
Very
so
grateful.
Please allow me to follow back.
We're slightly out of time, so that concludes this panel. We are incredibly grateful to you for your time and the candour of your evidence. Thank you very much indeed. That will help this committee get its recommendations to Parliament right. But that concludes this panel, and that concludes this session. Order, order.